All rise. Court of Appeal then for the Sixth District of the State of Florida is now set. Honorable Dan Traver, Chief Judge, presiding. All persons having business before the court shall hear the defendants and the will be heard. And God save the United States of America, State of Florida, and this honorable court. Please be seated.
Good afternoon, everybody. Welcome to an oral argument session of the Sixth District Court of Appeal. As Marshall Crawford said, my name is Dan Traver. I'll be presiding today. I'd like to introduce you to the rest of the panel. To my right, your left is the Honorable Mary Nardella, and to my right, your right is the Honorable Keith White. Before I call the case, just a couple of short housekeeping matters. This is being streamed live via YouTube. If you haven't silenced your cell phones, I would appreciate it if you did. Also, just because of the nature of the case and the fact that we're streaming, I would just remind the parties to address anybody who's operative in the case by their familial relationship with one another or by their initials. This is case number 25-374, OP, AP, and EP versus the Department of Children and Families. Mr. Sen, I presume that you're doing the argument today?
Yes, sir.
How much time would you like for rebuttal? Terrific. Whenever you're ready, sir.
Good afternoon. May it please the court. I'm Steve Sen, counsel for three siblings who are appellants here. Also at counsel table, Christine Smith, who represented the siblings in the dependency court. My clients have been separated from their sister as a result of dependency court placements in separate settings. And since March of 2023, they have had limited and sporadic interaction with their sister. That's because the dependency court and the department failed to comply with fairly specific requirements in Florida law, requiring that sibling relations be preserved, including, I think most pointedly here, there's a string of them that we review, but ultimately the guardianship order for their sister should have, by statute, included provision for visitation. That didn't happen. When the adoptive mother of the siblings complained, the department, we believe under the statute, then had the responsibility to raise the issue and to take steps to rectify that error. They did not do so. When the siblings then retained counsel and filed a motion to seek sibling visitation, the department took the position that the siblings are not parties and, quote, therefore have no standing and no legal rights whatsoever to request any relief in this action. That is a quote from what the department submitted. That quote was later, after the dependency court, we think got it right 3 times, but ultimately got it wrong when it quoted that provision in the order on appeal and denied sibling visitation. The court then did sua sponte order modest, and we submit inadequate sibling visitation, but only after making clear that he was going to disregard all of the relevant and material evidence that had actually been admitted during an evidentiary hearing. We say the dependency court got it right 3 times, just to review those quickly. When the siblings originally were seeking relief, they began with a motion to intervene as parties. The court denied that motion, and it denied it on the reasoning that they were participants, and as participants, they could pursue visitation without need for party status. We quite frankly think that's correct, they don't need to be parties. As participants, they should have been able to present their case for sibling visitation. The court later got it right again when it conducted the hearing. Well, first off, when it held the hearing in the first place, because that was the argument was they have no standing, we don't have to listen to them, we don't need to have a hearing. A hearing was scheduled, the court allowed that. And then during the hearing, the court admitted the relevant and material evidence that the siblings presented through their counsel, Ms. Smith, in the dependency court. Certainly there was some evidence that was disallowed just in any evidentiary proceeding. But the evidence that was relevant and material to the question of visitation was admitted. And so you have before you a finding that this is relevant material evidence, and it clearly is. It goes to things like the siblings for much of their early lives had regular visitation, and it was very much in their interest. There were pictures of them being happy and smiling together. There were pictures of the sister's room at the home of her siblings, and evidence from the caseworker that the visitation had been robust and should continue. In fact, it had been more than weekly until in March of 2023, it actually stopped. And so it was only when, after the evidentiary hearing, the department moved for reconsideration, making its arguments again that these children are not parties and they should not be permitted to seek this relief and present evidence, that the court reconsidered each of those prior orders and said, yes.
Counsel, the party participant distinction that this case hinges upon, and you presented case law from the second, we've seen case law from the fourth, it kind of goes down to what rights each status has. Outside of the dependency realm, thinking of something that may be similar, can you think of another case which would give us guidance on how far a participant can go, somebody outside a party status that doesn't have the access or the status of intervener? I think of Marcy's Law, and I couldn't find any cases dealing with that, and I didn't know if you'd had a chance to explore that avenue or could point this court to any other authority.
And you're speaking specifically to Chapter 39 cases?
Correct.
Well, certainly the one case that we cite where the court found there was a right to appeal and involved the city of Plant City, who was trying to get information in a dependency court case.
Correct.
And they were then allowed to appeal despite the department's arguing that they were not a party and therefore had no right to appeal. And that's the case where the court, I believe that's the JB case, where the court ruled that Article 5 of the Constitution says there is a right to appeal final orders. And interestingly, other provisions don't. Certain appeals are subject to legislative review in the Constitution, and so the legislature can properly, I think that's administrative appeals. Non-final appeals, the Constitution.
Separate questions, are they not? The right to appeal, right? Standing is a separate question based upon your level of participation. And I'm kind of asking a level of participation question. I didn't know if you had any guidance on that.
No, the cases that we found that pertain to it are as cited in our brief. But in addition to the case law on that, the biggest part of our argument is the word itself. A participant would suggest that there is some ability to participate. And then the argument that the department has been successful on thus far is based actually on the rule of procedure, which, make sure I get the language straight, defines participant.
And I understand that the root is the same. And I follow that argument, but what do you do with the definition? The fact that these have been defined terms?
Well, I think you can follow the definition, both as they're defined by statute and as they're defined by the rule, because under that definition, we accept that our role, the siblings' role, is as participants. And that role in 8.210B says participants may be granted leave by the court to be heard without the necessity of filing a motion to intervene and shall have no other rights of a party. That's the part the department has emphasized. But then those last 5 words are so important, except as provided by law.
You accept, though, that a procedural rule can't confer substantive rights.
I agree with that.
Let's go from there, because if that's the case, then the substantive law that it has to reference would probably have to come from either the Constitution or from the statutes.
We rely on the statute. Our client.
Yeah, so in looking through the statutes that you do cite, you've got 39-402, that relates to shelter hearings, which obviously isn't at play here. You've got 63-0427, which relates to adoptions, which also isn't at play here. You've got 39-4024, which does, I'll acknowledge, contain general legislative statements about the importance of sibling bonds and visitation, but it's also addressing placement, contact if they're not placed together, and regular DCF reviews, none of which would be in play if DCF's oversight is discharged, as it was in this case, due to a permanent guardianship. So I counterbalance that with my colleague's question about the express definitions of participant and party. And it seems to me like you're relying on, we'll talk about the Constitution and due process in a second, but it seems to me that as it relates to statutes, you're relying on some statutes with questionable procedural applicability to where we are here, to basically say that siblings should be impliedly included in the definition of party. And I confess that I think that even though you and your colleague did a fabulous job in terms of representing your clients, and I also think their desire to have visitation with their sister is admirable. I also think, for what it's worth, that the guardian's commitment to visitation with their siblings, with your client's adopted children, is admirable. But I'm having some real struggling. I'm really struggling with the idea that that general law comes from those statutes.
Okay, I have, if I can keep them straight,
Yes, sir.
three responses to that. First, 39.4024 encompasses legislative findings, which I do not believe are necessarily restricted to pre-permanency. These findings about the importance of children placed in out-of-home care to be able to continue existing relationships is not one that goes away once permanency is achieved. And that's demonstrated by the provision that a permanent guardianship order must include provision for sibling visitation. So the legislature has made clear this doesn't stop when a guardian is done. And also there's similar language in Chapter 62 that would indicate that they're
Saying 63.
63, yes, sir, that there should be provision for visitation of siblings. So the
But it's
legislature,
ability. Again, and I'll give you that there's general legislative intent in 39.402, but it's untethered to any sort of point in the process. You know, where the rest of 39.402, 4024, 402 is shelter hearings, 63 is adoptions, generally speaking. Where do we get that legislative intent imported into this specific situation?
where the legislature has said a guardianship order must provide for sibling visitation, I think if that's not an adequate tie, I'm not sure what is.
Well, fair enough.
Should have
But
been
in this
done, and that
particular
wasn't done
case, didn't the trial court on its own initiative add that visitation? I mean, nobody was questioning. I don't even think that the guardians were questioning that sibling visitation should occur. It was a question of frequency. So I don't necessarily know that the unquestioned, but perhaps remedied deficiency isn't what you're talking about in the guardianship statute. I'm just asking about your ability on behalf of your clients to get more visitation. It seems like all we have is a general statement of legislative intent untethered to anything in the midst of these two definitions.
Well, the rest of my second point I was going to make in response is the pendency courts have been guided forever by the idea that they have to operate based on the best interest of the children in their proceedings. And the legislature is saying as clear as they can, as emphatically as they can, that continuation of sibling rights is in their best interest and should be preserved. And not only should it be preserved, it is the responsibility of the dependency courts, the Department of Children and Families, and all of the adults in their lives to make sure that those are continued.
Let me ask you this. If we accept your argument that a sibling has a right under the statutes from somewhere to present evidence like a party in the context of seeking post-guardianship visitation, does that limit in any way the other contexts in which a sibling might have the same rights? In other words, would a sibling then, if we write this opinion the way that you would like to see it, in terms of reversing and saying, yes, you have this right to present this evidence, does a sibling have a right to present evidence in the context of an initial dependency finding? Does an adult sibling have a right to present evidence in a termination of parental rights proceeding? are they entitled to counsel? What is the general applicability of the holding that you're asking us to make?
It should be a moot issue if everybody's doing their job, if the department is doing what it is charged to do under statute to make sure this happens in the dependency court. It's only when all of those other responsible parties took no action and allowed this to happen that it even became an issue that the last person, and so in those other situations, if the rights of the siblings to sibling visitation, which is a substantive right that is at issue here, that the substantive right that is recognized by statute, and we think due process should attach to that substantive right, if that is being violated because the responsible parties
In
are
its
not doing their
estimation,
job.
though, it would be in the sibling's estimation, just like it is in this particular case. So if a sibling thinks as a result of an initial shelter determination or in the adult sibling context in the termination petition, that their ox has been gored in some way, wouldn't they then have the right to substantively come in and present evidence and act like a party?
Certainly, they would have the right to say my rights to sibling visitation are not being respected by whoever, and we want to have a hearing and the court make a determination.
And I appreciate you saying that. Like, I do admire the candor, but I don't know how that doesn't throw the entire legislative scheme on its ear. Wouldn't those people all be entitled to counsel then as parties?
That's another day for another case. Kids have generally not been allowed counsel, although there have been arguments on that from time to time. Most states, I shouldn't say most states, many states do allow.
Well, in
kids'
most
right to
cases, they
counsel,
get
but-
GALs, right? You know, like there's somebody advocating for the interests of the child that's at issue in the case. So let's say that they've got 3 different siblings in 3 different placements. Do they all get GALs too?
I don't know the answer to that. There was no GAL at all in this case, which might be part of why this continued to fall through the cracks by the other parties. But we're asking for, we're not asking to tear down the fence. We're asking for a narrow gateway to enforce the substantive interest that the legislature has very clearly recognized when that substantive interest was ignored by the court and by the department. And the only person raising their substantive rights were these kids. That is the size of the door we are asking this court to open. We're not asking to tear down the fence. A lot of the cases that have been cited against our position involve former caregivers, grandparents, potential adoptees. None of those parties have the substantive right that we are identifying that the legislature has provided to sibling visitation. And under the rule 8.250, participants may be limited and not be able to act as parties, except when they're enforcing their own rights. We here seek the ability to present evidence on the rights of these kids to sibling visitation as recognized by the Florida legislature. And it's not completely tearing down the process and cutting down the fence. It's narrow and limited. And in fact, we see how limited it is because you look at the transcript here,
You're pretty far into your rebuttal time. Do you want to keep, I'm not going to stop you if you want to keep going, but do you want to save some of it for rebuttal?
yes, sir. I'll save the balance for rebuttal. Thank the court.
Yes, sir. Ms. Hall, whenever you're ready, ma'am.
May it please the court. Good afternoon, your honors. My name is Meredith Hall and I represent the Department of Children and Families in this matter. The department submits to this court that they don't even have to, you do not even have to reach a decision on the merits in this court because there is no standing for a participant to appeal a dependency order. Should this court decide that it would like to reach the decision on the merits, or it can reach the decision on the merits, the department further submits that it should be through the mechanism of certiorari, extraordinary remedy. However, under either standard, the participants do not have, trial court did not err in the lower court proceedings when it denied the participants the right to present evidence, their request to present evidence in this case.
Counsel, can I take it from the top of your colleague's argument? Would you disagree that there's a substantive right of the sibling group to have a relationship and visitation with their youngest sibling?
Yes, Your Honor. I would, to the extent that I would say that the sibling does not have a substantive right to visitation being ordered in their siblings' case. In this case, SM was born after the children were already in the dependency case, in a completely separate dependency case, and were on their way to adoption. SM didn't even come into this case until she had been with her current caregivers for about a year.
So if this had been one proceeding, there would have been a right and they would have had a mechanism to enforce that right.
It depends, because in that proceeding, I do think that even in one proceeding, for example, if they were all sheltered at the same time, in this case, SM was not sheltered at the same time. So this is a completely different case number, and that's common in our cases. We do not automatically join later born siblings into dependency.
So counsel in their brief makes a point that this is, we are ordering procedure over substance, right? We have a wrong order of things. We should take the substantive right of the children to visitation over some anomaly that these happen to be different proceedings. What is your response to that?
My response to that is, one, it is not an anomaly, it's common. And second, it would still matter, the right that is at issue in a Chapter 39 proceeding, particularly one that is titled "In the Interest of SM," are the rights of SM, the child. They are not the rights of the siblings or any participants. Only the sibling has a right to assert visitation assert a right to visitation. Even the statute that they cite, 4024, has a provision in it under 6B3. When one child is part of the case and the sibling is adopted, there is only a permissive right for that child to have visitation. So even if SM was the one who wanted visitation, it was permissive. Now, if there was an adopted, in another scenario, which isn't applicable here, 6B2, it is when another child is no longer in out-of-home care. So let's say this case was open, because that is another important distinction. This case was closed. SM achieved permanency already. So that is another important distinction. But when there is an out-of-home placement of another child, and then their sibling is, let's say, reunified with their parent, then the child has a right. And it specifically states that the child has a right to continue contact. It does not state that the sibling has a right to continue contact. Excuse me, this is my voice. So I do think that the standing issue is a very important issue on appeal, because we don't even have to reach the decision on the merits. They did not have Section 39.510 and 9.146 of the appellate rules are very clear that that only a party can appeal a dependency order.
It seems like you've got a constitutional issue to circumvent if you're making that initial jurisdictional argument, though, which is, that you have Article 5, which talks about the concept of appeals as a matter of right, which the Florida Supreme Court has interpreted as a constitutional right to appeal an order that's final, which can be final as to a party. Would you agree that this order is final as to Mr. Sen's clients?
I have 2 points to respond to that. I do not think that order is final as to Mr. Sen's clients, because they were granted participant status. If they were denied participant status and were never allowed to be heard in this case again.
But what else could they do, I guess, is my question. I mean, if we affirm or we dismiss, then the situation is they haven't been allowed to present evidence. The trial court has made its determination. What else could they do as participants going forward in SM's case?
Well, I think then you'd have to look at whether the siblings actually had rights in this case. And
Well, whether they did or they didn't, if they didn't, then the order is no less final to them than if they did and they couldn't do anything else. So that's what I'm asking. I mean, I recognize that there are sometimes in dependency cases, interlocutory sorts of decisions, which means that somebody's not done fighting yet. But, my perception would be that if we take this case on its merits and we affirm it, it's a final order. So that's what I'm getting at, because if it's a final order, then I don't necessarily know that it matters what the Constitution or the statute or the rule of procedure says as to who can appeal.
well, Your Honor, the concept of final orders is contemplated at the end of judicial labor in this case. And the Florida Supreme Court cited in MM that post-dependency orders that are subject to future modification for the benefit of the child's welfare are non-final orders. And this is one of those orders. The order that they are appealing is a sua sponte order amending the permanent guardianship to give them sibling visitation, but less than they requested.
Yeah, and maybe I'm just not doing a good job asking my question, but like, as it relates to them, the siblings in SM's case, what makes it non-final? What more could they do? What other rights or initiatives would they be able to have? If we, for example, dismiss this appeal for lack of jurisdiction because it wasn't final.
Your Honor, to be candid, none. You do not have rights.
Well, that's what I'm getting, that's what I'm
Yes.
getting. So that's what I'm getting at, because if that's the case and this order is indeed final as to them, doesn't that constitutional provision then suggest that this court has jurisdiction? I mean, the merits are a separate issue, but as it relates to our court's ability to decide a final order, doesn't the Constitution expressly provide that right?
Well, Your Honor, the only rights that they had that could have been adjudicated by the court is to be a participant. They were given that right. The only right that flows from being a participant is notice and opportunity to be heard. They were given that right. They were given above and beyond that right because there were 5 hearings set on a closed case just so they could address their own issue of sibling visitation. And at the end of the day, they got exactly what they requested in their motion for sibling visitation that was struck way back in 2024. They requested that they get a court order setting a scheduled visitation. They did not specify in that request for relief how much time they needed, how much they thought was best for the child. They were solely advocating for their interest in having a court order set schedule of visitation. And they got it. They got it through a sua sponte order from the court, amending the permanent guardianship order and adding a sibling visitation order. So that flows into my point, my third point that, or I guess my first point to present is that there is no legal authority for a participant to present evidence in a dependency proceeding. The 4th DCA has recently addressed this in both BD versus CD, which candidly did come out after the appellant submitted their briefs. And then earlier in KN versus the Department of Children and Family, where this exact issue came up about who has a right in these cases. Well, I'm sorry, Your Honor, if I may backtrack. There is no statute that says siblings have a right to visitation and can present evidence in furtherance of their right. In Chapter 39, and I think Judge Nardella said this case does hinge on the definition of parties and participants, which is very specific to Chapter 39, is that Chapter 39 are confidential proceedings, and that is to protect the privacy of the people involved, because these are children that are victims of abuse, abandonment, and neglect. We do not want to let the world in to these cases because they're still children and they have a right to privacy. So it starts with completely shutting everybody out. Then it goes to who's a party, and parties are specifically defined. And then it goes into participants. And it was an acknowledgement by the legislature that there are people who have an interest in protecting the child's best interests. And I think it's important to note that in the definition of participants, siblings are not included. They are in a catch-all provision that says other persons who may participate if it is in the child's best interest. There is no provision within Chapter 39 or in the case law that states that a participant can assert their own rights in Chapter 39 proceeding. The focus of this case needs to be on SM because it's about SM's protection, SM's best interest. And the fact of the matter for this case is she achieved permanency. She is not an independent child. She is no longer a victim of abuse and neglect. She is not in the custody of the department. She's off living her private life with the only parent she has ever known. And there is just no mechanism for a sibling to come in and say, I know you agree to visit with me this much, but I want this much, and I want it at this location. It's not fair to SM, and it's not allowed under the statute. So
Would you agree that their argument, though, is colored in SM's best interest? I mean, the evidence they want to present on visitation is based upon an argument that this is in their siblings' best interest, not just in their best interest, is it not?
Well, that is the argument they make, and they do make it repeatedly, but they even admit in their initial brief that they are presuming that this is in SM's best interest. So one, they do not know it is in SM's best interest, and arguably it is SM's parent who knows what's in SM's best interest. But the second part of that, I'd like to reference a case that was only decided about 2 months ago, and I believe Judge Nardella, you were on the panel on this case, and that was In Re AJN. And in that case, which just follows along with what the 4th DCA and 5th DCA has already said, is that you cannot raise an interest on behalf of another party. especially constitutional rights, but your interests are to you. And it is not, and you are not allowed to raise them on behalf of somebody else. So I would argue that no, they cannot advocate for SM's best interests. And the SM's best interests were properly considered by the court by hearing from all the participants involved and making a determination on the minimum amount of visitation that they should have. And I will like to point out that that was just the floor. The court did not say you can only have this much. It was a minimum of this much once a month at an agreeable location. The siblings are, it was not a situation of denied visitation. It's not a situation where the department objects to visitation. Everyone agrees with visitation. And that's actually great in this kind of proceeding because the participants were adopted, we have no right to go into their adoption and force them to visit with SM. So if the situation were reversed, we couldn't do that either. Talking way more than I thought I would be today. So no, I do not, while they are presuming they know what's in SM's best interest, they do not have a right to advocate for SM's best interests. And that leads me to my final point that I think Judge Shriver brought up towards the end about the due process rights. The participants were given all of the process they are entitled to under the law. They are only entitled to notice and opportunity to be heard. They were given multiple opportunities to be heard. Due process rights are not just everyone gets to present evidence. It depends on the nature of the proceeding and the rights at stake. As I stated before, siblings do not have a statutory right or a fundamental right at issue in SM's proceeding. Rather, lost my train of thought, sorry. So, and I think the fourth DCA has reached this issue really well. The last two cases I cited, BD versus CD and KN, and they talked about that there are no fundamental rights at stake for grandparents because the only fundamental rights at stake in a Chapter 39 proceeding belong to the parent. And the Florida Constitution and the US Constitution has not extended a fundamental interest in raising children or to sibling relationships. And the other thing that I would like to address that I believe Judge Nardella brought up, perhaps, is that KN did discuss what opportunity to be heard looked like. And in that case, it was former foster parents objecting to the child being removed from their care to be placed with their sibling at that time. And the court in KN talked about how they were given the opportunity to be present at the hearing and testify in a narrative fashion about why they did not think the child should be moved. The court found that that was sufficient opportunity to be heard. So we do have a definition of even what opportunity to be heard is. In conclusion, the department respectfully requests first suggest that this court does not even have to reach a decision on the merits of this case because there is no standing to appeal a dependency order. Should this court reach a decision on the merits, the trial court did not err when it did not let the siblings present evidence in their case because the siblings there is no legal authority allowing a sibling to present evidence in their case. And there was no due process violation that occurred because they were given all the process they were entitled to under the law. If the panel does not have any more questions,
Thank you.
thank you so much.
Start off the due process issue. Our due process argument is founded upon the substantive interest that the legislature has made very clear that this is important. This is something that affects their lives and their outcomes. It should be granted and respected by the courts and everyone in their lives. That's the kind of interest when a state law recognizes an interest like that, due process should normally attach to that. And we're not taking the position that there's always a right.
Mr. Fenn, isn't there case law though that says the legislature can and does and has articulated statutory rights, but nevertheless, just the existence of a substantive statutory right does not give everyone a right of a cause of action to assert them. So that's what I'm struggling with is where do your clients have a statutory or a constitutional right? I will add minor clients. Because I also want you to address the disability of non-age issue. Minor clients have a substantive right to go into their sibling's case and articulate some right to visitation. And that they have the right to assert it.
Okay. Your question with the authorities you were citing, I believe, were implied causes of action. And of course, there's a lot of cases that just because the legislature passes a law that says these things doesn't necessarily provide for a cause of action. We're not suing anybody. We're simply asking for an existing proceeding where we have participant status to follow the law that applies to all of the children's rights to visitation. So the implied cause of action authorities, I believe, are not relevant here. The age of the kids, they're old enough to retain counsel. We're not here representing anyone other than these three children. They, throughout dependency court, often have rights to appear and to be heard. The judges ask questions of kids in dependency court all the time. They sometimes have their own attorneys to represent them.
You agree your clients have the disability of non-age, correct?
They are, I believe, 7 to 11 is the ages of the children involved.
So chapter 743 enacted by the legislature recognizes the disability of non-age. You agree?
They are not suing anyone, Your Honor.
Correct, but but they're coming into, you're asking them to have standing in court to assert what you're arguing is their own personal substantive right. So one, how do they get past, how do they have an ability to go into court when we're talking about a minor who normally doesn't have an ability to go into court?
Judge,
Hasn't been granted any authority. You were not appointed. No one was appointed as a GAL to represent the siblings, right?
Judge, I've read a lot of these cases over the last several months. If non-age was a barrier to kids asking to have their rights respected by the court, none of these cases need exist because they all should have been simply struck based on the kid has no right to be heard in court. But I do not believe that's Florida law. And the authorities that we have cited, many of them include children who are underage, but who still the courts have recognized. I think the interest of MS is a particularly a good example of that, where even before these sibling rights laws that we're relying upon were enacted by the Florida legislature, the Second District Court of Appeal ruled that sibling visitation is a sufficient right to which due process should attach. And in that case, it wasn't even the question of whether the child was a participant seeking sibling visitation. He was seeking sibling visitation, but the court said, you are entitled to an evidentiary hearing on whether you should have.
I read the case. I didn't see where is this underlying substantive right that inures into the sibling as opposed to a general right.
In MS, it was due process. In MS, the court said that the sibling has an interest. Well, the right itself to sibling visitation was one that comes out of the statutory and perhaps constitutional mandate of recognizing the best interest of the child. Best interest of the child, relevant to that, is visitation with their siblings. Therefore, if that has been interrupted and there's a question about whether appropriate sibling visitation has been granted, due process, according to this court, requires an evidentiary hearing on whether the best interest would be served by examining that question.
I realize that I have you way past time, but I did want to ask you about the due process aspect of things. And I'm sure you'd agree that due process is a flexible concept, correct?
Of course.
And one of your clients at least had the opportunity to tell the trial judge to his face what he wanted in terms of visitation with his sister.
Yeah.
And the participant statute speaks in terms of the opportunity of the right to be heard, correct?
Correct.
I just wonder how your clients weren't heard.
We're not taking the position that due process requires evidence in all cases. Clearly, if your motion or if your complaint doesn't state a cause of action, you don't get a trial. If you can't get past summary judgment, you don't get a trial. That's because there are no disputes of material fact that are relevant to the ultimate outcome. Here, there was a dispute between the guardian and the adoptive mother and my clients, the siblings, over what appropriate visitation was. That dispute of fact can only be resolved. The best interest of the child can only be determined if evidence on that fact is continued. And because this is a guardianship situation, the court has continuing jurisdiction to ensure the best interest of the child. Permanency does not end that role. I thank the court.
Thank you very much. Thank you both for your presentation. We'll take the case under advisement. Court is in recess.